Good morning, everyone. We're so excited to have you here today. Thank you for joining us. If you're here for part 2 of the training on Medi-Cal, Medicare, and Covered California, you are in the right place. My name is Mark Mora. I'm a senior policy analyst at Homebase. Homebase, if you don't know, is an organization that provides technical assistance and support to a number of COCs, continuums of care, across the nation, including the Santa Clara COC. I'm here with my colleague, Nicole, and we're just gonna help make sure everything runs smoothly and moderate the chat. Nicole, you wanna take a moment to introduce yourself?
Morning, everyone. Thank you for being here.
Awesome. So today is day 2 of the training on Medi-Cal, Medicare, and Covered California. The first day was on Tuesday, and part 1 of the series on navigating mainstream benefits was on CalFresh, and that was back in April. If you're interested in the slides or the materials from any of the trainings, including today, we will notify you via email when they're posted on the COC website. Just a couple housekeeping items regarding Zoom. Live transcript function is available. Should be able to go to your toolbox, which generally is at the bottom of your Zoom app, and then hit live transcript. Also, the chat box is yours to use. If you have questions or comments, please pop them in there. There will be designated times to ask questions. So if you're on a phone, or you just prefer to ask your question verbally, you can do that. Just make sure you hit mute again after you're done. If your question is in the chat box and it's not addressed right away, don't worry. Nicole and I are moderating that and collecting all the questions. We'll make sure the trainers get to them at some point. If you have tech issues at any point, feel free to direct message myself or Nicole. If for whatever reason you get kicked off and have trouble getting back in, you can email me at mark@homebaseccc.org. And today we're going to do a quick icebreaker. So I appreciate it if you'll humor me and participate. So if you could type into the chat box your name, your organization, and your favorite dessert. If you don't have a favorite dessert, I'm not sure we can hang out. I'm just kidding. Not everyone likes dessert, so if you have a favorite snack, you can post that into the chat. I will model this for us, so you know my name and my organization. My favorite dessert is cheesecake. I don't care what kind of cheesecake. I don't discriminate. If you put the cheesecake in front of me, likely it will be consumed in short order. So if you can please share your dessert, maybe I'll read a couple off. Let's see, Diane, strawberry pie, good choice. Megan from the Salvation Army, donuts, ooh. Catalina also likes cheesecake, but the strawberry cheesecake kind. I see Kevin with key lime pie. Let's see, what time is it? 9:30. Is it too early to eat dessert? I don't think so, right? Well, if you could, please pop into the chat and read off some of the desserts on there, but also gives you a chance to see the other folks in the room and perhaps give you some ideas of networking or connecting with folks that you don't know yet. So thank you all for doing that. Without further ado, I'm gonna pass it over to our wonderful trainers, Tiffany and Amy from Bay Area Legal Aid.
Good morning, everyone. Thank you for coming. This is day 2 of our presentation about the healthcare programs that are available for folks in California. And if you weren't here the first day, we talked a lot about eligibility for Medi-Cal and Covered California, and a little bit about Medicare. And Bay Area Legal Aid is a nonprofit law firm. And we, the organization as a whole, provides legal assistance to low-income people. Tiffany and I are part of our Health Consumer Center, which is a division of Bay Area Legal Aid, and we provide assistance to folks who are having issues with health insurance or healthcare access. And on the first couple of slides, we put some information about, there we go, about our hotline and availability. So if you have any questions about individual cases, feel free to call our hotline. All of us who answer the phone are attorneys, and we'd be happy to help you out with individual cases. You can also shoot us you know, a direct email if you have more general questions about you know, requirements for Medi-Cal or Cover California or anything like that. So today we are going to talk about primarily the three main topics are state fair hearings and appeals. And then second is COVID-19 and things that have kind of changed or been adapted to deal with the pandemic. And finally, so Tiffany's going to talk a little bit about tools or tips for navigating these systems for folks who are experiencing homelessness. And then after that, we're going to take some time for questions, and then we'll go through a few hypotheticals that will go through some of situations, bringing in some of the information that we talked about yesterday and today, just so you can kind of get a better sense of how these rules might look in a given situation. Okay, so to start off, what can I appeal? And when I'm talking about appeals today, I'm primarily talking about Medi-Cal and Cover California. Medicare is an entirely federal program, so its system for appealing is completely different. So we're focusing on state appeals today. But what can I file an appeal about? Basically, almost anything. Requesting a state fair hearing is a great tool to it's a problem solving tool, if nothing else. And some of the things that you can appeal, specifically application denials, like sometimes people file an application for Medi-Cal and then just don't hear back from anyone. So you can kind of just file an appeal for delays or denials. If terminations, sometimes Cover California plans get randomly terminated. You can file appeals for that. Sometimes there is a disconnect between Medi-Cal and Cover California. You can appeal that. If something changes with subsidies for Cover California, share of cost problems, virtually anything you can, even just kind of, miscellaneous issues that someone might be having with their Medi-Cal, this tool, this ability to file an appeal is great because if you're having trouble getting a problem solved by just talking to a caseworker or the customer service line for the county office, filing an appeal will get you assigned to an appeals officer, and you'll be kind of assigned to their docket. And within, usually less than a week, you'll get the contact information to a person who's assigned to your appeal. And they have an incentive to help you figure out the issue and get it resolved so they can take it off their docket. So sometimes we just use this as a tool, even if it's not just a straight denial, if it's just something we just need help with and we need the attention of someone from the county and we haven't been able to get it so far, we file an appeal just to kind of get it escalated. A lot of times that will resolve the issue, but if it doesn't, then you can go to a state fair hearing. Next slide. Okay, so appeal rights for Medi-Cal and Cover California. It's part of, so we all have a constitutional right to due process. And so part of that, case law throughout the year has basically mandated states to have this system where if your benefits are being terminated or if you're being denied government benefits, you have this ability to file an appeal and be heard, on the record regarding, the problem that you're having. So for Medi-Cal, and I believe Medi-Cal and Cover California, you have 90 days from the date of the notice of action. Sometimes, a lot of times, if it's like a denial or if there's, an explicit action that has the county has taken or Cover California has taken, you'll get a notice. It'll have a day on it, a date on it. And so it's pretty clear, what the deadline would be. Sometimes if you're kind of appealing inaction, it can be a little bit hazier when the clock starts ticking. But, it's always, if you have an issue, it's always a good idea to appeal early. And that's for eligibility. For healthcare services, so it's a little bit different. Like, let's say your plan denies this prescription drug, say, that you need, and they want to, switch you to something else or terminate it. Then there's a little bit different process. So you file a grievance with your health plan first, and then once the health plan has finalized its decision, then you have 120 days from the date of the denial from the health plan to request a state fair hearing. And I put those asterisks there because these are things that have been adapted a little bit currently due to the pandemic. And aid paid pending. This is a great way to kind of prevent people from losing benefits immediately due to, a notice of action. So if they say you're no longer eligible for Medi-Cal as of June 1st, if you appeal appeal a decision before the action goes into effect, you get to continue your benefits throughout the process of appealing it. So because an appeal process could, depending on whether it's going to get resolved early or not, it could take a couple months. And this makes it so that people don't have to go a couple months without benefits while they're, appealing a decision. So I have an example here. So John receives a notice of action dated August 5th, 2020, that his Medi-Cal benefits would terminate on August 31st, 2020. He appeals the proposed termination on August 12th. Because he appealed before the termination occurred, he'll get to receive aid paid pending, and his Medi-Cal will not terminate pending the appeal outcome. Next slide. Okay, so state fair hearings, these are before an administrative law judge, which is a quasi-judicial body. So it's kind of like a court, but it's not going to be exactly like going into a courtroom. And the administrative law judge will take, the hearing will be under oath. So, you raise your right hand and swear to tell the truth. And it will be based, the claimant will have an opportunity to provide testimony, facts, supportive documentation, and make an argument about why you think that the agency's decision is incorrect. It's pretty informal. Right now during the pandemic, all hearings are happening by phone. In normal times, it's a mix. Usually they're in person, but it's a mix between whether they're in person or by phone. And you can ask for a video hearing too. We don't usually do that in well, I haven't done that so far in my hearings just because it can be a logistical problem sometimes with some of our lower income people to try to do a video hearing during a pandemic. But it's informal. People can represent themselves. You don't need an attorney for it. And if you don't have an attorney, the judge will explain the process and make it's supposed to be simple enough that, regular people, non-lawyers can do it themselves. And you have a right to present your case and provide testimony and submit what you need to submit to prove your case. So the judge is not allowed to, stop you from presenting your case because you have, a constitutional right to present your case. The evidentiary rules are relaxed. So, when you go into a real courtroom, there might be, objections based on evidentiary rules. But during these state fair hearings, those rules are relaxed. There are still some some rules of evidence that, you know, a judge may require, you know, documents to be authenticated in a specific way, but they'll kind of let you know and help you walk through that during the hearing. But yeah, so it's not it's a little bit less stressful when you don't have to think about all the evidentiary rules that are required in like a real courtroom. And so the county also has the opportunity to attend the hearing and present why the agency made their decision and kind of justify the agency's decision. Usually they provide a statement beforehand, like a statement of position within a week before the hearing. And so you know exactly what their position is going to be beforehand. And a lot of times they just read straight from their position statement. And then, you know, you kind of have an opportunity to ask them questions, to cross-examine them and ask them questions about their position and to get that all out on the record. And after the state fair hearing decision is released, you have a 30-day deadline to request a rehearing if you are unhappy with the result of the hearing decision.
Okay, I will take it over from here. This section will be discussing the protections that have been put in place due to the COVID-19 pandemic. I'm going to focus specifically on the Medi-Cal protections, and then Amy will cover the Covered California protections. So for Medi-Cal, there has been quite a few protections that have come out in the past year. The biggest one is that due to the federal emergency health order that a pandemic is happening, and if there's a emergency crisis, the federal government has put out that emergency health order. The state of California has adopted that order and also declared their own public health emergency. And due to that, they have instated a prohibition on negative Medi-Cal actions. That means the counties in California are not terminating Medi-Cal benefits during the pandemic. So until a health order is lifted, Medi-Cal benefits, any negative actions on Medi-Cal benefits cannot be taken. That means if someone has Medi-Cal, full scope Medi-Cal, they cannot be moved to a share of cost because that would be a negative action. Share of cost Medi-Cal is not full scope and does not cover the same, does not provide the same level of health access that full scope Medi-Cal has. So if you see that happening to any of your clients, that is something that can be appealed, or you can call our hotline for tips on how to resolve those type of issues. The counties are well aware of this prohibition. So we haven't seen many actual negative actions take place since this order has been put out. Some, cases slip through the cracks here and there, but they can be fixed quite easily. So that means even if someone actually doesn't qualify for Medi-Cal, if their income has increased and they no longer fall beneath the income limit, if they are subject to an asset test under the Asian disabled rule and their assets are actually above that limit, even though they don't qualify for Medi-Cal, the counties cannot terminate those individuals due to the pandemic. You still have to report any changes in income to the county. That's still a requirement, but the county just can't take action on that. There are some exceptions. Death, if you request that your benefits be terminated, if you move out of state, or if you move into long-term care Medi-Cal. Long-term care Medi-Cal has different rules for eligibility and coverage compared to what is called community-based Medi-Cal, which is what we've discussed so far during our trainings. So long-term care Medi-Cal, for the most part, has a very high share of cost. So the counties can assess that share of cost if someone is seeking long-term care paid by Medi-Cal. If you're a first-time Medi-Cal applicant, you can be denied and you can be given a share of cost. This protection on negative actions only applies to Medi-Cal recipients or ongoing Medi-Cal recipients. Like in the previous slides, Amy mentioned the appeal deadlines. So if you disagree with a decision made by the county or by your health plan, the normal appeal deadlines have been extended due to the COVID-19 pandemic. Now, if you get a decision by the county, you have 210 days to appeal that. Previously, it was 90, but anytime during the pandemic, as long as that emergency health order is still ongoing, you now have 210 days. If you have a negative decision by your Medi-Cal managed care plan, you have 240 days to appeal that as well. So the extensions are quite generous. Another protection that has come out is renewals. Renewals are essentially an annual event that happens for Medi-Cal beneficiaries. They're also called redeterminations, but every year the county will send out a packet for beneficiaries to renew their Medi-Cal, which just means that they're supplying income information, asset information, if that's applicable, and providing this information to the county so they can reassess eligibility for Medi-Cal benefits. These renewal packets are still being sent out to Medi-Cal beneficiaries, but the counties are not processing them. So any beneficiaries that send them in to the county is just holding them. They're not actually processing these renewals. If someone does not return the renewal packet, normally you could be terminated for failure to renew, but also during the pandemic, they are pausing that. Another big benefit right now is the waiver of premiums. So we discussed the 250% working disabled program on Tuesday. This program does have a small premium depending on the amount of employment income that you receive. The premium is as low as 20, but it can go pretty high if you are a high earner. Medi-Cal does have a children's program. For higher income recipients, the income limit can go up to 266% of the federal poverty level. So these two programs do impose a waiver. For the children's program, it's about $13 a month. But during the pandemic, you can ask to have a waiver of these premiums. You don't have to pay it. It can be paid retroactively to March 2020, which is when the official pandemic started. If you request retroactive waiver of those premiums, you won't get a refund, but they will use those premiums that you previously paid as a credit towards future months. But for any future months that you request a waiver, you do not have to pay the premium for these programs. The federal emergency health order is supposed to end in September, but it can get renewed. California is essentially just following what the federal emergency health order says. We think it's likely that it will be extended to the end of the year, but it's not a guarantee. So at this time, until September, there shouldn't be any negative actions. As we get closer to the fall, there might be another renewal. Another protection that has come out is the Department of Healthcare Services, which is the California government body that oversees and administers the Medi-Cal program throughout California. They created the COVID-19 uninsured group. This is temporary, but it will provide free COVID testing related services, and any treatment services that are COVID related. This group is for people that are uninsured, or if they have private insurance that does not provide free COVID-19 related testing and treatment. And this is for people that do not have insurance through another source. So if you're not eligible for Medicare, you could apply for this program. If you don't have free Medi-Cal, you could apply for this program. So individuals on a share of cost could be put under this COVID-19 uninsured group so that if they do need any COVID related treatment, they can get it free through this program. They have to apply with a Medi-Cal approved provider. So the provider would have to help them or submit the application on their behalf. The link goes to the list of approved or qualified providers for this program. For everyone else, if you are a full scope Medi-Cal beneficiary, there is no share of cost. You are not on a restricted scope Medi-Cal. COVID related treatment is free. You should not be charged. There is no charge for testing, for the vaccine, and any treatment that you get that is related to COVID. In general, Medi-Cal beneficiaries should not be paying for any medically necessary services, but for COVID-19, it is also explicitly free. The COVID-19 stimulus checks that came out through the acts are also exempt for Medi-Cal purposes. If there is a difference with Cover California, which Amy will cover, but for Medi-Cal purposes, the checks are not counted. The unemployment benefits are usually counted for Medi-Cal purposes. That is considered income. But the supplemental pandemic assistance that was provided last year, that extra $600 a week, and then the current extra $300 a week, that pandemic specific unemployment benefits are not counted for Medi-Cal eligibility. So the counties do not take that into account for anyone that is applying for Medi-Cal and receiving those benefits. All right.
Okay, so for Cover California, so the several changes have been made to Cover California, and some of this is through federal legislation, and then California itself has kind of strengthened some of those protections. For example, the Cover California Marketplace Exchange is open for enrollment through the rest of 2021. As we explained yesterday, generally you need to have proof of a qualifying life event to sign up for our Cover California plan outside of the open enrollment period. The open enrollment, so the open enrollment period, it's actually, they call it a special enrollment period, I think, but you don't need any proof that anything specific happened. That has been extended. The federal government through the American Rescue Plan Act, they extended enrollment through, I believe, the end of August, or it may have be the end of September, but California, extended it through the end of 2021. So, you know, the Cover California protections are a little bit stronger there and allow for open enrollment through the rest of the year. The federal government increased the amount of the advanced premium tax credits that people get, and also so they lower the cost of the monthly insurance premiums, and these should be applied automatically for people who are already in a Covered California plan. So people they should have by now realized or gotten notice that their Covered California plan, if they get these advanced premium tax credits, their premium will go down if they didn't already have a zero or low monthly premium anyway. So individuals with income below 150% of the federal poverty limit will have zero in premiums for both 2021 and 2022. This is a little different. Normally folks would have, would still have a premium if they were at 150%, between 138 and 150%. So anyone who has received unemployment insurance benefits at any time in 2021 is eligible for Cover California for the year, and they'll pay $0 in premiums, regardless of what their actual income ends up being. So if they, if it turns out that their income is well above 150% of the federal poverty level, they won't have to reconcile and pay back anything. The IRS is just going to assume, they're just going to, not require them to reconcile that and allow them to have these $0 premiums regardless. So this next one was a pretty great thing that they did. So people who have received excess advanced premium tax credits federally. This is only federally. Don't have to reconcile and pay them back. So at this time of year, usually we would get a lot of calls from people who after filing their taxes found out that they received a lot more in these advanced premium tax credits than they were entitled to receive, and are finding out that they have a very large debt to the IRS. And that can be very, very hard to deal with, because it often means that they didn't report a change that they should have reported, and there's really no way to go back and undo it. But luckily this year, as this is especially important because a lot of people's incomes were very volatile in 2020. So it would be really hard for people to, amongst everything else, to keep up with reporting, a lot of changes in income throughout the year. And a lot of people reported an income that was well different than what their income ended up being. Oh, so I see a question that came in that said, would people pay $0 premiums regardless of the plan they choose? I don't think so. I think, so generally with Covered California, they, everything is based on a silver benchmark plan. So yeah, you wouldn't be able to pick like a, like a really expensive plan and like a gold plan and then still pay the $0 in premium. So most things are based on a silver plan, which is kind of just like a medium use plan. Okay, so yeah, people that received excess, people don't even have to reconcile this year for federal taxes. Usually people would get a tax form, it's called a 1095A, that's, most people get it either way, that says like what months you had health insurance, and this form would say how much people got in advanced premium tax credits, and then when they file their taxes, they would, it would calculate what they should have gotten and then what their debt is. There's a separate form for that, and they don't even have to file that form. So they just, whatever they got in tax credits, they can just kind of ignore anything with that. So they wouldn't have to worry about reconciling. That's not the case with state tax credits. So I talked a little bit yesterday that 2020 was the first year that California started having its own premium tax credits in addition to the ones that the federal government offers. And those are usually for people that have a little bit higher incomes, above between 400 and 600% of the federal poverty limit. And then there's some additional benefits for people under 400 to make it even more affordable. But so for state taxes, people still have to reconcile. So they didn't waive this. California didn't waive the requirement that people have to reconcile their taxes. So that could still end up being a problem for folks with a little bit higher income. So yeah, COVID-19 stimulus checks. Stimulus checks are not counted for Covered California purposes. And the supplemental pandemic unemployment benefits are countable. So that, like Tiffany said, that's different than for Medi-Cal. And this last note, I just wanted to add this on here because there wasn't really anywhere else to put it. But this really is affects a lot of people who may have been laid off from their job, due to the pandemic. And so the American Rescue Plan Act, which was signed into law in March, it implemented this subsidy for people who are eligible for COBRA, even if they didn't sign up for it in time, because usually I think you have to sign up within 60 days, I believe. It could be 90. There's a time limit that you have in order to sign up for a COBRA plan. But even if you missed that deadline, if you would otherwise be eligible for COBRA, you can sign up for it, and there's a subsidy so that the government will pay the entire employee amount of the COBRA premium from April 1st through September 30th. So that a lot of people I recently had a case now where someone had a Cover California plan, but then they realized that after having been laid off, but then they realized that they could switch to this COBRA subsidy and get a little bit better insurance from their COBRA plan because their employer plan was a little bit better than their Cover California plan. And so they were able to kind of switch to back onto COBRA, which they didn't select initially because if you have any experience with COBRA, it generally you're responsible for both the employee and the employer portion of the health insurance premium, and so it's really expensive often to try to pay out of pocket. So a lot of people waive COBRA because they can't afford it. So this allows people to continue with the health coverage that they had before they were laid off, without being burdened with huge premium amounts.
Okay, the next section, I'm just going to discuss some tips and rules for navigating Medi-Cal in general, and then specifically for persons experiencing homelessness. And so the biggest one is the county of residence. So to get Medi-Cal, you do have to be a California resident, but it is the individual county offices that actually do the eligibility and evaluation and provide those benefits. So your Medi-Cal is going to be based on your county of residence. Most people that are Medi-Cal beneficiaries will join a managed Medi-Cal plan, which we've discussed. Those are also county-based. In Santa Clara, it's Santa Clara Family Health Plan and Anthem Blue Cross, and I think some people have Kaiser. But those plans do not necessarily contract with providers that are based outside of Santa Clara County. So you are kind of limited to your county of residence in receiving services. So a person that is experiencing homelessness, they do have to designate one county as their permanent residence, but they can temporarily reside in different counties, and that will not affect their where their Medi-Cal is based. It would be a disruption to have to move your Medi-Cal county from Santa Clara to Alameda to San Francisco on a frequent basis, because transferring the county, the Medi-Cal county case is called an inter-county transfer, and it's generally a long process. We do see a lot of delays with inter-county transfers. So for those experiencing homelessness, they don't have to change their county, even if they're temporarily residing in a different county. For Medi-Cal managed care enrollment, your Medi-Cal plan will be based on your permanent county of residence. So that does mean that even if your county is based in Santa Clara, but you go to San Francisco, you cannot use your Santa Clara plan in San Francisco. The plan will expect you to get services within your county, so you would need to return to that county to actually access services. There are some exceptions if, for example, your Medi-Cal plan does not have providers in network that can treat you, if there is a shortage of providers, if they don't have the expertise to treat your condition, but you would have to go through a process to get that approved. And that oftentimes can be difficult to prove that your specific plan is not equipped to provide you the level of care that you need. For mail, it would be very important to have a stable address where mail can be sent. Medi-Cal really only sends information in written form. I mean, it is a due process right that you get a notice of action before any negative effect on your benefits, so that you have the chance to review that notice and then appeal if you feel that you disagree or the county or health plan is making an incorrect decision. So the notice of actions are sent by mail. The renewal forms normally are also sent by mail, and other requests for information will also be sent by mail. So a person that's experiencing homelessness, they could use a family or friend's mailing address. They don't have to put that family or friend's address as their permanent address, but just as their mailing address, so that They do get mail. A PO box would work. USPS does offer general delivery, so that's also an option as well. Or designating an address with like a community shelter or something along those lines would also work. The next one are state fair hearings. Generally, during the pandemic, state fair hearings have been done by telephone. And then, like Amy said, there is the option for a video hearing as well. In regular times, state fair hearings can be conducted by telephone or in person. For basic Medi-Cal rights, you have a right to an in-person hearing. That means that you get to see the administrative law judge that will be overseeing the case. And if the county or the health plan is going to show up to show or prove why they are taking a certain action, you as the beneficiary have the right to see them in person if they are attending. So if you have a telephone hearing, you could convert it to an in-person hearing, and you are allowed to do that. They cannot say no pre-pandemic. And sometimes that could be easier for individuals if it's difficult to be reached by phone. ACMS is the online state fair hearing portal that the State Hearings Division has instituted. It started about 2 years ago. It's new, but you can file for a state fair hearing online, or if you file it by phone. But there is a website where you can sign up for an account, and you can see the different notices that were sent and attached to the case, the county's position statement, which details the evidence that demonstrates why they are taking a certain action. And then you can also upload your own documents that you need for the hearing and everything like that. So for residency, sometimes it can be hard to approve residency, but a letter from a homeless shelter or other community service agency stating that they're receiving services from that agency and in that county can be used. Counties are also required to accept telephonic attestations and affidavits for Medi-Cal eligibility. So if you do not have something that says, I live here in this county, or I earn or I receive this benefit, you can use an affidavit by telephone to demonstrate that you meet the Medi-Cal eligibility rules. Except for citizenship or immigration status, the counties can accept these sort of telephonic attestations and affidavits. Generally, the county is going to want the actual pay stub or something along those lines, or a letter from Social Security saying you get this sort of benefit. But if worse comes to worse, you can provide it through a telephonic attestation or an affidavit. Or if you're not receiving any income as well, you can also attest to that by phone. There are some accommodations that can be made. If you need extra time to provide documents to the county to either prove that you qualify for Medi-Cal or as part of the renewal process, you can ask for more time. When counties do a renewal, by law, they're only supposed to ask for information they do not already have access to. So someone that is receiving like CalFresh, sorry, not CalFresh, but CalWorks or another county benefit, they shouldn't ask the client to prove that in their Medi-Cal renewal, because the county has access to that information because it is also another county benefit that they are receiving. But typically what the counties will do is they send out a renewal packet, which is several pages long, and that has the previous information on file. And then if there is any change, or if there's any extra information that the county wants, they will request that you either correct the form or provide it when you return the packet. But the renewals, they can also be completed in different ways. They don't have to be sent by mail. They can be faxed, they can be emailed, they can be provided in person, or you can even call the county over the phone and complete the renewal with a person and say, this is correct. I live here, or this is my new income, or I need this change in household, or something along those lines. But the counties cannot refuse to complete the renewal information over phone, by email, or in person. All right, so we were going to stop here and answer some questions that anyone has. There was a question from Tuesday about whether or not, well, what proofs are required to prove common law marriage for Medi-Cal purposes. So if someone's in a common law marriage and they wanted to be added to the Medi-Cal household, how do you prove that? We are not quite sure. This is actually a new question for us. It has not come up, but we're going to look into it and research it, and then we'll provide Mark and Nicole our answer so it can be shared with the group. And in terms of other questions, trying to get to the chat box, but I don't think I can.
There are no questions at the
Okay.
moment, Tiffany.
All right. Well, if there's no questions, we can always move on to the hypotheticals and answer any at the end of our hypotheticals as well.
Okay, so in this example, we have Sam, who's applying for health benefits through covercalifornia.com. He's 45 years old, unmarried, and is not disabled. He has about $50,000 in checking and savings combined, and he makes about $1,200 per month in employment income and has no other income. What health plan might he be eligible for, and what would change if his income was from SSDI instead of employment? I'm not sure if anyone wants to try to answer this, or I can just kind of go through it. If someone does want to try to answer it, let me know. Okay, so we can, it's kind of an issue spotting. So when we get calls like, you know, with specific situations, we kind of just have to run through all the rules that we know about each type of health program. So we know at $1,200 per month, his federal poverty level income is less than 138%. So for this year, a household of one, the FPL, 138% of the FPL is 1,482. So we know that he's income qualified for Medi-Cal. And we also know he's not disabled and he's under 65. So then it would be Magi Medi-Cal that we're looking at. And from what we know, it looks like he would be eligible for Magi Medi-Cal. There could be some, you know, some facts that aren't in this pattern that could make him ineligible for Magi Medi-Cal. For example, if he doesn't have a qualifying immigration status, or if he's married and is, I guess it says he's unmarried, but there may be other circumstances that would disqualify him. But from what we can see, it looks like he should be eligible for Magi Medi-Cal. If his income is from SSDI, that means that he has you know, a disability that's been determined by the Social Security Administration. So then he's no longer eligible for Magi Medi-Cal, because Magi Medi-Cal is only for people who are under 65 and are not disabled or don't have a disability determination from Social Security. So age and disabled Medi-Cal is a little bit different than Magi Medi-Cal, whereas Magi Medi-Cal does not have an asset test. Aged and disabled Medi-Cal does. So there's this $2,000 a month, or $2,000 at any given time asset limit. So he's going to have to do something about that $50,000 that he has as like liquid assets. So we haven't, I don't know if Tiffany spoke, can't remember how much Tiffany spoke about how you can deal with assets if you're trying to qualify for Medi-Cal for people who are eligible over 65 or disabled. But there are a couple different tactics you can use to get rid of that that money. You can basically you can spend it on yourself generally. You can also purchase exempt assets. So if he had $50,000, you get one vehicle in a one-person household, so he could buy himself a car. He could buy himself household furnishings. There's kind of exempt assets. He could there's a irrevocable burial trusts that he could try to spend some of that money on, but he would have to get the countable asset limit down to below $2,000. Okay, here we have Mark. He lives with his unmarried partner, Mary, and there are 2 children, Missy and Molly. Missy's 12 and Molly is 22. They want to apply for Cover California. Who would be in Mark's household for Cover California purposes? Okay, so for Cover California and Magi Medi-Cal programs, your household for benefits is based on your tax household. So because Mark and Mary are unmarried, they would need to apply separately for Cover California, because when they file their taxes, they can't file as a married couple filing jointly, which you have to do with Cover California. If you're married, you have to file jointly with your spouse, except in some very limited circumstances. But they're not married, so they can't. They wouldn't file married filing jointly on their taxes, so they would need separate applications. And as for their children, it depends on which parent is going to claim which child as dependents for tax purposes. And because you're applying for Cover California in the tax year, or slightly before it, and then you file your taxes later, you have to anticipate how you're going to be filing your taxes. So if maybe last year they claimed, I think Molly was the older one in my example, if they claimed her last year, but this year she doesn't want them to claim her as a dependent. She wants to go out on her own and file her own taxes based on her own income. They would just need to tell Cover California, whichever of the parent had traditionally claimed her as a dependent, they would just need to tell Cover California that they don't plan to claim her on their taxes for that tax year. And then Molly could go on and apply for Medi-Cal maybe, or Cover California, or whatever it is that she might qualify for. She can apply for that on her own if no one is claiming her as a dependent. And just another note that I didn't put in here is that in my example, Missy is 12. So it is possible, because for Medi-Cal, the income limits for children are slightly higher in Medi-Cal than they are for adults. So 266% of the poverty level is the income limit for Medi-Cal for children. So there are situations where there are what we call mixed income household, or mixed households, where the parents might be on Covered California because their income is maybe at 220% of the poverty level, but then the child would be on Medi-Cal because the household income is lower than 266. So that does happen sometimes. I know a lot of times people are really unhappy about that because they want their child to have the same health plan, health coverage that they do. But the way the rules work, if someone is eligible for Medi-Cal, they can't turn down Medi-Cal in order to qualify for Covered California. So that's just something that happens when families are applying for Covered California benefits.
Okay, so in our next example, we'll be talking about eligibility for Medi-Cal. So Sally is 59. She receives Social Security disability at $1,200 a month. She has Medicare now. She has been on the age and disabled program for a long time. She becomes eligible for a pension, and she receives $475 per month in addition to the Social Security disability. So her income is going to go up to about $1,675 a month. She notifies the county, and they tell her that her Medi-Cal is now under a share of cost, and it's going to be $850 a month. She cannot afford her medical care with the share of cost in place. Her assets are below $2,000. What can she do? So for Sally, Medicare is not a needs tested program. That won't be affected. She'll still have Medicare as her primary insurance, regardless of what happens to her Medi-Cal. But as we discussed Tuesday, one of the big benefits of having both Medicare and full scope Medi-Cal is that Medi-Cal will pay for the Medicare cost. Medicare itself is not free. There is a monthly Part B premium, which currently is $148.50 a month. Someone that has full Medi-Cal, like Sally, Medi-Cal is paying that Part B premium on their behalf. They also will pay for, Medi-Cal will also pay for the Medicare co-payments for Medicare Part B. Medicare only pays 80%. The leftover 20% is usually the beneficiary's responsibility. If you use hospital services, there are also related co-payments. But when you have free Medi-Cal, that's all being covered. If you have a share of cost Medi-Cal, because now the county or Medi-Cal is going to expect that you as the beneficiary will start paying for a portion of your care, your Medi-Cal does not become active. It does not kick in until you have met that share of cost. So for Sally, because her income is above the income limit, which for a single person under the age and disabled program is $1,482, her income is $1,675. She does not qualify. So she would have to keep her share of cost Medi-Cal or try to do some other strategies to reduce or eliminate her share of cost. So because of the public health emergency declaration, right now, Sally is safe. The counties will not actually change her Medi-Cal to a share of cost. So she can still access that until the public health emergency ends. But once it ends, the county then can institute that share of cost. So some options that she has is she can deduct any medical insurance premiums from her gross monthly income. Her Part B premium, that $148.50 can be deducted. That is what's called the Wobbler Rule. And essentially, what used to happen is that someone that had share of cost Medi-Cal, they would pay that Part B premium for 1 month. That premium, because it was deducted from their gross income, made them eligible for full scope Medi-Cal. They moved to full scope Medi-Cal. But when you get full scope Medi-Cal, Medi-Cal is paying your Medicare premium. Sally can no longer use that Part B premium deduction. So the next month she'd move back to a share of cost. So individuals would go back and forth between the free Medi-Cal and the share of cost, and it was very confusing. But in 2020, that problem was eliminated. So now essentially that Part B premium can be continuously deducted. So individuals don't have to go back and forth between share of cost and free Medi-Cal. So she can deduct the Part B premium of $148, or she can get onto the 250% working disabled program. Under that program, again, all disability-based income is completely exempt. They will not count the $1,200 she receives in SSDI, and they will only count the pension income of $475. $475 is below the income limit for 250%, so she would qualify. She would just have to show that she has some sort of minimal employment and provide that information to the county and ask to be put on that program. Okay. So our next example, Joseph is 67. He is single. He receives $2,275 in Social Security retirement. He has Medicare. He pays the $148.50 a month for Part B premiums, and he also bought a $60 vision insurance. So he pays $60 a month for that vision. He has $1,800 in his checking account. Would Joseph qualify for free full scope Medi-Cal? No. The income limit again is $1,482 for a single person. Joseph is at $2,275. He is clearly above that limit. So he could deduct his medical premiums to reduce his share of cost amount, but the medical premiums combined are not enough to get him below the Medi-Cal income limit. So his share of cost would be $1,446.50 each month. And this is the calculation is how the counties will calculate the share of cost. You take your gross income, $2,275. You deduct the medical insurance premiums plus the automatic $20 deduction. Joseph's income minus all of those deductions is $2,046.50. So his non-exempt income for Medi-Cal purposes is the $2,046. That is still above the limit of $1,482. So a share of cost will be assessed. And then the share of cost will just be his non-exempt income minus the $600 maintenance need level that the government has set for a single person to pay for their food, rent, utilities. That's $600 for a single person. So you take the non-exempt income minus the $1,600, and that is how the share of cost is calculated. So Joseph will be expected to pay up to $1,446 before Medi-Cal will kick in for any medical services he needs in a month. So as you can see, the share of cost can be quite expensive. The higher income that you have, the harder it is to qualify for free Medi-Cal. Theoretically, Joseph could buy, several $100s of medical insurance to reduce his countable income, but that is not really feasible or advisable. But it is quite difficult for those that have income that are much higher than the Medi-Cal income limit, because there's only so much you can do to try and get onto free Medi-Cal. And that is the end of our presentations. But if anyone has any questions, feel free to speak up or chime in.
I don't see any questions at the moment, Tiffany, but maybe we can give folks a minute or two to see if anybody wants to add anything to the chat box, or they can unmute if you want and ask a question verbally. I do see a question. Will this be offered again in the future? I don't know if Nicole, you want to speak to that one.
I was trying to fiercely type in the chat, but you beat me to it. We do try and offer a Navigating Mainstream Benefits series annually. So yes, I think we look forward to kind of hosting this yet again, maybe with some other, it lasts, or 2 years ago, it was a 4-part series, so we might bring it back with some slight changes, but this is a training that we know participants have a lot of questions and interest around, so it will be brought back. And yes, all of the resources that were shared today will be sent out, so you can reference later.
Yeah, we sent the PowerPoint that we had sent out earlier didn't include these examples. We added those in yesterday. So we can send out, you know, the updated copy if people want one that shows the examples that we just did at the end.
I see your question. Are recordings for both days available? Yes, the recordings will be made available on the COC website, and everyone will get an email when those things will be posted.
I see a question about additional resources for the 250% working disabled program. I believe that there are some handouts or something. I don't know about you, Tiffany, but I think that somewhere we might have a publication that someone else completed about that we can try to find and send out.
Yeah, we can look through the handouts. There's quite a bit of information online, so we can include that with the PowerPoint in our answer to the common law question. Now, we definitely encourage people to reach out to us at Bay Area Legal Aid. You can call the line with a client, you can email, or you can just call the line for advice. A lot of what we covered also has a lot of additional exceptions and nuances to it. So there are little things that come up that would just be too much to put into a presentation because of all the different income rules that Medi-Cal has. So we definitely encourage people to reach out to us if there's some additional questions, or if you have a client with a tricky situation you want to refer over.
And if it's okay with you, Tiffany and Amy, I'm going to be sending a follow-up email after the training to thank everyone for coming, and I can include your contact info in that email if that's something you think would be good.
Sure. And we also have another colleague who wanted to have me circulate his contact info too. His name is Andy Lay. You may have met him before, but he operates out of our San Jose office, and he just has a pretty broad network of contacts in Santa Clara County, more so than the rest of us do. So we'll include his information as well.
Perfect. So if there are no more questions, I'm going to close us. But before you go, if you can, I'm going to pop the training survey link in the chat. If you could please fill that out. It only takes a couple of minutes. We really appreciate it. It would help us to improve and tailor trainings moving forward. And I'm sure the trainers would love to hear your feedback. So yeah, if you have any questions, again, you could reach out to Amy or Tiffany. I'll include their info in the thank you email. But just want to take this opportunity to thank Amy and Tiffany for being such great trainers. Feel free to show them some love in the chat box, or you can use those little reactions on the bottom of the toolbar in Zoom. But thank you again, everyone, for joining us. And I don't know if Tiffany, Amy, you want to say anything else before we go?
I don't think so. Thanks, everyone.
No, thank you.